Any mention?
Yes.
May please, Your Lordship. Lordship, I beg to make a mention of item 2, Your Lordship. Item 2.
Item 2. The first item of the hearing. Yes.
Lordship, I'm praying for 2 weeks accommodation.
Why?
Lordship, senior counsel is out of station, Your Lordship.
I have no objection, Lordship. It's no question matter.
The Learned Counsel for the petitioner prays for adjournment of the matter by 2 weeks. Learned Counsel appearing for the respondents have no objection. Prayer allowed. Disturbed for 2 weeks. Yes.
Obliged.
Please, Lordship, I beg to mention item number 11 and for respondent number 3. Your Lordship, I pray for 2 weeks' time as the conducting counsel has some personal
No
difficulty.
objection, Your Lordship.
Is prayed for by the Learned Counsel for the respondent number 2 and not objected to by the Learned Counsel for the petitioner. This is matter for 2 weeks.
Right,
Yes.
Lordship.
Highly obliged, Your Lordship.
Yes, Lordship, may I beg to mention item number 5 and 6?
Yes, what happened?
Your Lordship, in this case, state has filed the affidavit, but no copy is given to me. Last occasion, I
No,
request.
that is the submission which was
Last occasion also I request, Your Lordship. But
My apologies, because thereafter he also did not contact me. I also forgot me. My
that
apologies.
is not the way. She cannot be so casual. See about so far.
I'll give it. I'll hand over to them.
So what do you want today?
so, Your Lordship, let it come after 1 week, Your Lordship.
After 1 week.
Yes, sir.
No objection, Your Lordship.
Yes, Mr. R. Demat, Learned Counsel, we are paying for the respondent number
Respondent, 5 and 7. 5, 6 and 7.
in both the matters.
Oh, both the matters.
That is correct or not? Just check it. Please for. Just say on the prayer. Just say on the prayer made by Mr. So and so, Learned Counsel, this is matter after the week. Yes. Make sure you supply him a copy.
Yes, Lord. I'll do it.
May I please, Your Lordship? I beg to mention item number 13, Lordship. Due to personal difficulties, Lordship. After 1 week, Lordship.
Yes.
No objection.
At the request of the Learned Counsel of the petitioner, this is matter after
1 week, Lordship.
1 week. You should take it up this matter after 1 week. After 1 week, this is matter after 1 week.
Highly obliged,
Highly
Lordship.
obliged.
Please, Your Lordship, I beg to mention item number 8, Your Lordship. I pray if this matter may come up after 2 weeks, Your Lordship.
We have no objection.
This is a criminal appeal.
Yes.
The appellant is in jail.
Yes, Your Lordship.
So why you are delaying it? 2022 matter.
Conducting counsel has some difficulty, Your Lordship.
That is for your own interest. What is the sentence? What is the quantum of sentence?
6 years, 11 months.
And how long? 6 years, 11 months.
11 months he has been convicted by Joy Session Group.
6 years, it means around 7 years.
Yes, sir.
Yes. Okay. On prayer made by the Learned Counsel, appearing for the appellant. List this matter after 2 weeks.
2 weeks.
All right.
Highly obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 12, Lordship.
Yes.
I pray for 2 weeks, Lordship.
Who is appearing for the
I'm
respondent?
appealing for this.
Yes. Okay. This is also just prayed for by the Learned Counsel for the appellant. This is matter after
2 weeks, Lordship.
2 weeks. Yes.
Obliged.
Lordship, I would beg to mention item number 7. This is a joint request, Your Lordship.
Item 7. Yes. What happened?
Lordship, I pray this matter maybe come after 3 weeks.
Mentioning on behalf of the petitioner.
Yes, Your Lordship. Lordship, on behalf of respondent 1 and 2, Lordship.
You want it after 2 weeks?
3 weeks, Your Lordship. 3 weeks. It's a joint request, Your Lordship.
Just as prayed for by the Learned Counsel. As prayed for by Mr. So and so. Are you there, advocate on record?
No, Your Lordship.
Your name is there.
No, Your Lordship. I'm just mentioning on behalf of Mr. Nongri.
Just say the prayer of Mr. So and so, Learned Counsel, appearing on behalf of Mr. Philemon Nangri, learned counsel for the petitioner. And is a paid for by so and so, isn't it? Petitioner. This is what is it? And not objected to by the learned counsel for the respondents. This is matter after 3 weeks. Yes.
Obliged, Lordship.
Please, Your Lordship. Lordship, I beg to make a mention of item number 9, Your Lordship. Lordship, I pray this matter may be listed after 2 weeks, Your Lordship.
Other side?
I am for 1, 2, 3, my lord.
How many are there? 4.
4, your my lord.
5.
Total 5, my lord. I'm sorry.
You are appearing for 3.
1, 2, and 3.
And what the other 4 and 5? No one entered appearance.
They appeared, my lord. They appeared. Except for 5, my lord. 4 had appeared. 5 has not appeared, my lord.
The request made on behalf of the petitioner. This is matter after 2 weeks.
Yes, Your Lordship.
Right.
Obliged, Your Lordship.
May I please, Your Lordship, I beg to mention item 10, Your Lordship.
Item?
10, 1, 0.
Yes.
The state government have to submit the status report, Your Lordship, until now. Sir Abraham, the conducting counsel.
So why you are saying it to the mention of ours? Wait for the matter to be called.
Okay, but I'm mentioning, Your Lordship, I pray for 3 weeks' time, Your
So
Lordship.
that is a different thing. You
Yes.
come to that thing. Yes. What happened to this matter, Mr.
But we are praying for some more time.
Is it a matter which Mr. Abraham also appeared for
Yes,
some
yes.
time?
In
So
fact,
he
it's
was
his matter.
supposed to obtain some
Yes, my lord.
instruction
In fact, it's his
about the
matter.
latest status
Yes,
and
my
all.
lord. So he's praying for some more time. On his behalf, I am
You
praying.
do not have any information.
No, my lord, not yet.
Okay, yes, speak with the learned counsel of the petitioner. This is matter after 3 weeks.
Much obliged, Your Lordship.
Yes.
Supplementary counsellors, item number 1.
Yes.
Yes. Please, Your Lordship. Lordship, I'm filing this application for recall of the order dated 18/10/2024 passed in WPC 29 of 2018 and also for restoration of the petition, Your Lordship. Your Lordship, here the petitioner, he was not informed that the council...
What is the matter about? Is restoration? It is dismissed for default.
Your Lordship, the annexure 1 is... Page 6, Your Lordship. Annexure.
You must have defaulted more than once. That is why.
Your Lordship, there are 2 default appearances.
Normally, this court doesn't dismiss
Your
if there
Lordship.
is single default.
Your Lordship, here the petitioner was not informed by the council that the council itself is... They are not interested in the matter.
That is the common sense, isn't it? Huh? They are not represented by you.
No, Your Lordship. By
Some different council.
Different council, Your Lordship.
That is why you have taken that ground. Yes.
Lord, as far as the restoration is concerned, my lord,
This is 2018 matter.
2018.
Why it is pending? This is service matter.
Service matter,
Yes,
Your
ma'am.
Lordship. Pleadings are completed in this matter.
Yes.
in
We
fact, my
have
lord, we
filed-
had also filed a written argument.
You are ready for hearing on merit right now.
Right now, Your Lordship.
We'll restore and we'll hear it.
Lordship,
Tomorrow. Anyway,
Lordship, next week, Your Lordship.
hide. So, learned counsel appearing for the applicant. Stop. Next paragraph. Learned counsel appearing for the applicant and also Mr. So-and-so learned counsel appearing for the state respondents. You are also appearing for the respondent number 3, Mr.
Yes, yes, my lord.
The principal of Shillong Polytechnic.
Yes.
Learned counsel appearing for the so-and-so. And just this. By this application, the applicant has paid for recall of order dated 18/10/2024 passed in WPC number of 29 of 2018 by which writ petition was dismissed for default. The Learned Counsel for the applicant submits the applicant was totally dependent upon the counsel who was representing him. And he had no information as to the non-appearance of the then counsel representing him on the date on which the writ petition was fixed for hearing. So the applicant submits that the Learned Counsel for the applicant submits that the applicant is not at fault for his previous non-appearance, and he is very much interested to pursue the matter. Very interested to pursue the matter and prays for restoration of the writ petition number 29 of 2018, WPC number 29 back to file. Stop. Then we said Mr. Happy Battery, the Learned G appearing for the state respondent has no objection to the prayer made to the prayer for restoration of the writ petition. Stop. Then paragraph. And say in view of the submissions made by the parties, the reasons for previous non-appearance of the applicant is deemed to be good and sufficient reason. And accordingly, the order dated 18/10/2024, passed in WPC number 29 of 2018, stands hereby record. Stop. The writ petition number 29 of 2018 stands restored back to file. Okay, so this miscellaneous application is allowed. Then come to the writ petition. Just in view of the order passed in case number 201 of 2024, this writ petition stands restored back to file. When do you want it?
Lordship, if it may be fixed on 2nd of December.
We're not giving a date. We'll just.
I'll pray for 2 weeks, Manor, because next coming 2 weeks I'll have some difficulty.
So you also stops as prayed for by the Learned Counsel for the parties. List this matter after 2 weeks.
Highly obliged.
Make sure you take it up next.
Your Lordship.
Daily list, item number 1.
Two and three.
Who is appearing for 2 and 3?
Since they have not given.
Who is appearing for 2 and 3? D. Mauri. Where is he?
He's for 2 and 3.
No, I'm not.
Where is means?
4. Oh, sir. 2 and 3 is absent. That means.
You are Mr. Majao.
Yes.
2 and 3 were supposed to file show cause. I have not got
2
a
and
copy
3,
yet.
they have entered appearance. They have not filed Wakalatnama. Who is 2 and 3?
Ms. D.
Who is
Maori.
Miss D. Maori? Now this is this is something very bad on the part of the bar. You see, like this should not happen. This should not be the practice which lawyers should follow. Otherwise, nowadays will not allow anybody to enter appearance without an Wakalatnama being filed before he enters appearance. This is bad. No, not a very good practice. And because of one or two lawyer like that, this entire bar will lose its credibility. You should share among your colleagues. It should not happen. Something not very appreciable. See, now this court becomes in wrong position. The court believes lawyer who somebody enters appearance, we record, and then the office note says that forget about filing objection. This lawyer has not even bothered to file his wakalatnama also. What is to be done in this situation?
Lordship, I'll contact Ms. D. Maori.
You try to contact, but this is not the way, you see. If they have any difficulty, they should at least come and appear and tell the court.
Yes.
That under miscommunication she has entered appearance. It is not the way, you see, one day you make appearance and next day you disappear. Very bad. Please convey the displeasure of the court in this kind of situation. It will have a far-reaching consequence. Then all the advocates will face this kind of problem. The court will not allow them to say anything without having proper authority. Otherwise, normally, whenever somebody stands up on your behalf, say something, we do not disbelieve. We allow it, isn't it? And that is the culture which prevails, is prevailing for time immemorial. It should not go. The trust should not go. So what is to be done today?
Your Lordship, I'm from respondent number 4. I want to file an affidavit on the next day.
You will be filing on objection. Okay. Mr. P.K. Bora, the petitioner in person. You are not corrected the cause title, Mr. Bora. You are supposed to correct the cause title.
Yes, I thought my juniors had corrected it. They had said.
You should verify. You see, you cannot go by this.
I'll do it
today
only. Today only.
The office note dated 18/11/2024 indicates that though one Miss D. Maori, Learned Counsel, had entered appearance on behalf of the restaurant number 2 and 3 on the previous occasion and prayed for grant of 2 weeks' time for filing objection in the matter, the same has do not say the same, the said counsel has not even filed her wakalatnama before the registry. Neither there is any objection filed on behalf of the restaurant number 2 and 3. Today, after full stop, today when the matter was called out, none entered appearance. But do not say none stood up to represent the said restaurant number 2 and 3. Stop. The said office note also indicates that the petitioner has also not taken steps for correction of the cause titles in the revision. In this revision application, as ordered earlier. State is filing any objection, madam? No.
Lordship, not at the moment.
Not at the moment means when?
Lordship, after I see their after I see their objections. The objections of 2 and 3.
That is not Anyway. You are not supposed to file your objection on basing on the objection filed by the others. You cannot adopt that strategy. It is not legal. Either you say you will file or you say you do not file. What is the last time? Mr. P.K. Bora, from the petitioner representing person, place for and granted 2 days time to make necessary correction in the cost title of this revision application. As per order, as per that we have already said, isn't it? Order revision. That's not. Mr. Majao. Mr. S. Majao, Learned Council appearing for this number 4. Place your grant of some time for enabling for filing an objection in this matter. Prayer alert. List after 2 weeks. 2 weeks. You correct your thing. And madam, if you please can locate who is Miss Devi Mauri. Tell her if he's a young peppered lawyer and all, tell her not to adopt this kind of strategy. This is the second time this court has come across this kind of strategy. It's not good, especially for young lawyers. The lawyers should not think that they can do whatever they want and they will escape. You see, they will escape from all this. Not correct always. You all have some responsibility. When you stand up, you say something in the courtroom, you say it with full responsibility.
Hearing item number 3.
Yes.
Lordship, I'm for the respondent, Your Lordship.
Nobody is for the petitioner.
Mr. Jha, Your Lordship.
This is a problem, you know. These old betters, nobody appears. None appears for the petitioner. We appear for all the respondents.
Yes, Your Lordship.
So and so appears for the respondent. This is matter after when?
After 2 weeks, Your Lordship.
After 3 weeks. Yes.
Obliged, Your Lordship.
Item number 4.
Yes.
Lordship, the learned JSGI is on legs, Your Lordship, before courtroom number 2.
So what is to be done?
My lord, this is that matter, that Cook matter, my lord. So my lord has in fact heard it on several occasions, my lord.
Yes. Then what for
That's
you
your
are waiting at this stage, Mr.
My lord, only my lord, I had sought time from this honorable court regarding, my lord, because some to the point judgments, my lord.
Time, yes.
To the point judgments.
Yes, you have got something.
My lord, I have got 2 judgments, my lord, but I am looking for a few more, my lord.
See, what law requires that you should have sufficient time.
My lord.
Now, what would constitute sufficient time? That is what is required.
My lord.
You may not get, you see, like a decision on exact time.
My lord.
Because no two cases similar. See, no two cases.
That is the problem, my lord.
That is one thing we bear in mind. But then, if we can get some principle in this kind of situation when examinations are held on phase wise, or like your case,
Yes,
on the basis of court's order. Now, whether the candidate who appears later in the subsequent stage should also have the same, you know, like.
That is exactly what I am, my lord, looking for, my lord. That, my lord, although equal opportunity, my lord, I found a lot of judgments, my lord.
Because you see, just because the at the time of the main examination, the candidate had got 1 month's time. For you, when a subsequent exam is held, specifically for the purpose of accommodating you, see, this giving 1 month time is illogical.
No, my lord.
So you cannot be placed on the same footing.
No.
But then, whether if it is to be time is minimized, then what can be? Whether it is for
Lord,
few
my thing is that, my lord, my humble and respectful submission, my lord, that even if they had given me 2 days or 3 days or a week's time, that would have sufficed, my lord, because I was taken by
so
complete
that is according
surprise, my
to
lord.
you should not be on the same day.
Yes, my
Now
lord.
that is what, just give us something. Because otherwise, normal thing is that you are an expert,
My lord.
isn't it? So performing for doing your own performance, you do not need time. That is a normal conception, isn't it?
But my lord, my humble submission, my lord, even assuming, my lord, all the others are also experts, my lord. But irrespective of that, my lord, they've got sufficient time, my lord, a month's
So
time.
that is what would constitute sufficient time. Give us something.
My lord, so that is to the point.
So for until and unless you show us something, this court
Lord.
court may say that yes, 1 hour is sufficient enough.
No, my lord, at least even a week's time would have been. My lord, what had happened, my lord, is that I was completely taken by surprise. I was called for one particular test, written test. Now, even, my lord, even had the call letter somewhere given a small indication, short indication, my lord, that in case you qualify, then you will have to sit for the trade test on the same day. Even that would have sufficed, my lord.
But then you
But there
being
was not a
candidate,
single intimation, my lord.
you being a candidate, you should be ready for that.
Because, my
They
lord,
did not tell you that the trade test will not be held on the same day. See, two things. The imputing bias on them may not be always possible, because if you want to say that they have done it to oust your candidature, then they could have made you fail in the first part of the exam. But then that is not the case. You cleared the first part of that.
and I cleared the second part also, my lord. I cleared the physical because I had to redo the physical. Then I
There are
redid.
3 parts it is.
Yes, my lord.
So first 2 parts you cleared.
First two parts.
So that is not that you see like you.
And, my lord, the day I did my physical, my lord, then thereafter they issued a call letter giving me a different date for.
Now, assuming that you make out a case, then what would happen? Is there any vacancy where you can?
My lord, yes, lord, because there's 40 plus vacancies, my lord.
That was there at the time when this
My lord, even till this date is not filled up, my lord.
The positions.
Yes, my lord.
Because all the participants are like you.
No, my lord, the selection, my lord, out of the, my lord, this much vacancies, my lord, they were, to my information, my lord, of course, they have denied all other informations, my lord. At max 2 to 3 candidates must have got, my lord.
So still you have vacancies.
I have
Because-
limited instruction, Your Lordship.
Because they
If you
have
have
not.
vacancies, take him.
My
He
request,
must have improved by now.
my only request was, my lord, that I be given another chance to sit for the
See,
trade
from
test, my lord.
2017, and we are in 2024, 7 years. He has become now a very experienced cook.
So my humble request was only that, my lord, that kindly give me another chance to sit for the trade test. That is all, my lord.
Ready
I'm
to
not
do
saying that you give me appointment.
You're ready to do that.
No
Before
instruction.
that, he will prepare food for you, taste it, and then you give it. That will be okay. Anyway, when do you want it? You think you'll find out something on that, or you want to go ahead with the hearing?
My lord, because only if I can, because I understand my lord's queries, my lord. So only to that point, my lord, if kind enough
No,
to
we can
grant.
give you, if you want, we can give you, but then you have to find it out. It should not be just you ask time for the sake of
No,
time.
no, my lord. In fact, for on equality of opportunities, my lord, they are innumerable judgments, my lord. Now the only problem is, my lord, because I had to suffer not because of my fault also, my lord.
Well, on prayer made by Mr. K.P. Virgil, learned counsel appearing for the petitioner and not objected to by the learned counsel appearing for the respondent. This is matter after 2 weeks.
My lord.
Please find out.
Yes, my lord. My lord, only my humble request, my lord. Till 6th, I'll be slightly difficult, my lord.
What is the date today?
Today is.
Make it 3 weeks. Make it 3 weeks. So 3 weeks will not come
After
up
2
before
weeks,
6th?
my lord, after 6th it can come up, my lord. Any date after 6th.
Today is
My lord, today is night.
make it after 3 weeks.
My lord. Obliged.
Obliged, your lordship.
My lord, another humble request, my lord. In the meantime, my lord, I will also try to prepare a short written argument.
That you can do it. You have the
Well,
liberty to do it.
well.
You see, this will basically a kind of thing. If you do not make a lengthy argument,
My lord.
instead, if you make a gist of your
My lord.
argument,
My lord.
only you give bullet points.
Yes, my
that helps.
My lord.
You do not need always these things. If you have prepare it, that is help us, and you can always raise your short points of
My lord.
law.
My lord.
That no adequate opportunity was given,
Yes.
no sufficient time was given.
My lord.
That will help, but then do not make it very lengthy.
My lord.